Hello, my name is Mary Sawicki. Welcome to Prosecutor's Brief. Today our topic will be defending the forensic interview against claims of suggestibility. Number 1. Prosecutors need to familiarize themselves with the forensic interview structure that the forensic interviewer was trained on in this particular case. For instance, how can a prosecutor really analyze a forensic interview for signs of suggestibility if they don't know anything about the forensic interview structure that the forensic interviewer is trained on? So, number 1, the prosecutor really needs to consider taking training on that particular forensic interview structure. That would be, I think, very, very helpful for the prosecutor. In addition, to prepare to defend the forensic interview against claims of suggestibility, get to know your forensic interviewer in the case. Learn from the forensic interviewer. The forensic interviewer is well trained in the structure that they utilized that day at the forensic interview, and of course they were the interviewer. Meet with the forensic interviewer ahead of time. Pick their brain about why they did what they did in the forensic interview. For instance, if they begin the forensic interview building rapport with the child, ask the forensic interviewer, why do you do that? Why is building rapport so important? So for prosecutors, again, take training in the forensic interview structure that is utilized in your jurisdiction, and also get to know the forensic interviewer that will be your witness if the case goes to trial, and learn from them about the interview structure that they utilized that day. In addition, when you have trial preparatory meetings with the forensic interviewer, ask them, did any issues come up? Is there anything I need to know? For instance, what if in this particular forensic interview, the forensic interviewer inadvertently used the name of the alleged perpetrator, the defendant in the criminal case, before the child did? So that is a challenging issue for the prosecutor. Was that action by the forensic interviewer suggestive? So it's really important that the prosecutor knows how to meet these claims of suggestibility. So again, in the trial preparatory meetings with the forensic interviewer, go over that forensic interview and discuss any signs of suggestibility. So what is suggestibility? What are we talking about? Well, potentially there could be defense claims that the forensic interviewer either did or said something or used nonverbal communication with the child to suggest answers to the child. So that is something that is a common defense claim. What can the prosecutor do to prepare for this? The prosecutor needs to know about memory and suggestibility research, especially for newer child abuse prosecutors that are just coming into the field. Contact the National Children's Advocacy Center. There's a wonderful reference librarian there named Muriel Wells. And Muriel can really set you on the right track, and ask Muriel, what are the 10 or so major memory and suggestibility peer-reviewed research articles out there that I can read and I can become familiar with? Because those particular research articles will become important as you analyze a forensic interview for any claims of suggestibility and learning how to defend that. So what are some techniques to defend a claim of suggestibility in a forensic interview? Some of the things a prosecutor can do is to emphasize in direct examination of the forensic interviewer and for redirect examination of the forensic interviewer to emphasize how many times the child corrected the forensic interviewer. So the child's correcting the forensic interviewer if there is a misstep by the forensic interviewer. So, how could there be suggestibility? The child is correcting and using their own words to correct the forensic interviewer. If there is a deviation from like a traditional protocol, meaning the child was brought in for more than one interview, or the child interview was lengthy, emphasize to the court and the jury why that happened. So, for instance, there would be many reasons why you could bring a child in for more than one interview. Maybe there are more facts or more alleged perpetrators, or the child was just not comfortable talking the first time around. If there are any errors in the forensic interview, for instance, that the forensic interview structure wasn't traditionally followed, meaning, say, for instance, it did not start out with rapport building, for instance, if that's the first step in the forensic interview structure that you're talking about. Ask the forensic interviewer why. Oftentimes, it might be a situation where the child is, discloses some abuse initially in a forensic interview, and the forensic interviewer doesn't ignore that, but questions the child in regards to that. Another thing a prosecutor can do is always emphasize on direct examination of the forensic interviewer and redirect of the forensic interviewer that the questions that the forensic interviewer used were, on the whole, non-leading and non-suggestive. And you have to remember, prosecutors, there is no perfect forensic interview. Just like there's no perfect opening statement or closing argument, there's no perfect forensic interview. But as a whole, emphasize that this forensic interview was done by a trained professional, trained in a certain forensic interview structure, and the questions asked were non-leading and non-suggestive. Another common defense claim may be that the forensic interviewer used a tool during the forensic interview, like PlayDoh. And oftentimes you may hear defense claims that bringing PlayDoh into the interview room is suggestive. It's incumbent upon the prosecutor during the direct examination, in my opinion, to explain to the jury that PlayDoh being utilized in the forensic interview isn't a toy, but it's there as a coping mechanism for the child to relieve stress and sort of a distraction for the child as they talk about some very sensitive things. In addition, there might be a defense claim that any human figure drawings or anatomically correct drawings are suggestible to the child. If those were used in a forensic interview, it's just so important that the prosecutor brings out to the court and the jury that, for instance, these human figure drawings were used properly, for instance, only used for clarification purposes. And in conclusion, it's so important that the prosecutor bring out during direct and redirect that the forensic interviewer has no bias or motive in this particular case and does not know the parties. Thank you.
Thank you for watching this episode of Prosecutor's Brief. If you have questions or comments, see the contact information listed below. If you'd like further information, please check the links to Calio, the NCAC online library, and other resources listed. As always, thank you for the work you conduct each day in protecting the children in your community.